the Senate State Government Policy and Finance and Elections Committee. Thank you very much, everybody. Today is February 23rd, 2022. It was a fun day yesterday hearing about the 22 and all the twos and the babies born and all kinds of interesting little statistics that are happening out there. So yesterday was the day of the twos, but as we noticed, time marches on, so here we are on the 23rd. So welcome, everybody. Glad to have you here. At least the weather is not quite as bad as it was yesterday or the day before. It was a little bit iffy for everybody. And glad to have you all here in person especially. So with that, I'm going to have Ms. Wilson take the roll.
Senator Kiffmeyer.
Present.
Senator Howe.
Present.
Senator Carlson.
Present.
Senator Clausen.
Present.
Senator Fateh.
Present.
Senator Korean.
Present.
Senator Pratt.
Present.
Senator Osmic.
Present.
A quorum is present.
Thank you very much, Ms. Wilson. We do have a quorum. With that, we'll go right ahead and enter into our agenda for today. And our first bill is Senate File 3241. Senator Howe, as a member of the committee, you can go ahead and make your motions as you go ahead. And one question I have, again, more for the general public. Did you have an amendment as well?
No, Madam Chair, I do not believe I have an amendment.
Okay.
I believe
All
the
right.
bill is in the form I prefer.
All right. And Senator Howe, even still for the audio record, name and all that kind of stuff. Okay.
Thank you, Madam Chair. I'm Senator Jeff Howe. A pleasure to be in front of the committee instead of part of the committee today. I'd like to move Senate File 3241 to be passed and referred to general orders. But the discussion on the bill, Madam Chair, is most folks we've heard this bill last year in the form of an amendment on the Senate floor, where we placed that, I believe, on Senate File 1040, if I remember right. But what this bill does is it prohibits MMB from using pattern settlement or pattern bargaining when there is a current salary survey done by the OLA available for MMB to use, showing the dispensation and how the state law enforcement folks compared to other law enforcement agencies in our state. So, and actually the OLA is designated to use or do a salary survey in 2021, 2024, 2027, and 2030. So, Madam Chair and members, there's going to be an active current salary survey out there for roughly till about 2032. So there's no reason why MMB shouldn't be using that current data to determine the pay raises for our state law enforcement folks. And with that, Madam Chair, I'd like to go to my testifiers, if I may.
Thank you very much, Senator Howe. Definitely, we'll go ahead and have Mike Ledoux come up first. And then also Ms. Julie Seams, if you would come on up and take a place at the other chair. Welcome, Mr. Ledoux. Appreciate having you here today.
Thank you, Madam Chair. Madam Chair, committee members. Madam Chair, would you like me to spell my name for the committee?
It's always good to really helps people. Thank you.
My first name is Mike. My last name is Ledoux, L-E-D-O-U-X. Madam Chair, committee members, again, my name is Mike Ledoux. I've had the honor and privilege of being a state trooper for almost 28 years. I am currently the president of the Minnesota State Patrol Troopers Association, and I testify today in that role. I am also the current chair of the Minnesota Law Enforcement Association, representing all non-supervisory state law enforcement officers during collective bargaining. I want to thank Senator Howe for authoring Senate File 3241 and thank him for his advocacy and tireless efforts to improve the wage disparity issue for all state law enforcement officers. The purpose of this legislation is to provide a sound and comprehensive system for determining appropriate compensation for state troopers and other state law enforcement officers. In February of 2021, the legislative auditor released a clear, concise, and objective report detailing the large wage disparity for state troopers when compared to the 34-city comparison group established in State Statute 299 D03. This comparison group was established by the legislature in 2020. The OLA report indicated the top base wage that could be earned by state troopers in 2019 was substantially less than top base wage available to police officers in most cities reviewed. It's important to recognize this large disparity was based on 2019 wage data. The legislative intervention taken during the special session helped mitigate the disparity at starting wage, but a large disparity still exists at top wage. As a result of this market adjustment, the State Patrol moved from 33rd place on the list to 30th place based upon 2021 wage data. This disparity hurts career earnings, retirement benefits, and creates retention and retirement issues. This wage disparity was created as a result of the practice of pattern settlement and 5 years without contractual increases from 2003 through 2012. This exacerbated the disparity. The pattern settlement plague has done immeasurable harm to state law enforcement officers and their families for the majority of my career. As a result of the well-documented hiring crisis, experienced law enforcement officers have become like free agents, and they're turning away from lower paying agencies into training departments instead of destination departments. The current State Patrol Academy was funded for up to 75 troopers, but currently only has 13. SF 3241 strengthens the salary survey language of 299 D03 and provides much needed legislative oversight for 10 years to assure that this wage disparity is eliminated, so we can continue to recruit, retain, and retire these dedicated public safety professionals. We have attempted to address this wage disparity issue for the last decade and have been unsuccessful. For a lack of a better term, we have collective begging. Take what the state offers or go to arbitration, since we are essential employees and lack the ability to strike. State law enforcement officers put service before self each day for the security, benefit, and protection of the people as described in the state constitution. Please recognize their service by supporting SF 3241. Madam Chair, I would be happy to answer any follow-up questions and appreciate the opportunity to testify.
Thank you very much, Mr. Ledoux. I think we're going to hold our questions. I do have a few, but as we try and do, is have all our testifiers go first. But thank you for being available for that. And so now we'll go to our next testifier, and that is to Ms. Seams. Welcome to the committee. Go ahead and state your name and title for the audio record, and then proceed with your testimony.
My name is Julie Seams, JulieSiems. I'm on the board for the Minnesota Conservation Officers Association, and that's why I'm
Can you
here
lean
today.
real close into the microphone?
Yep.
It's
Is this better?
much better. Just,
All right.
it'll sound extremely loud to you, then it's just right for everybody else.
Okay. All right. Madam Chair and members of the committee, thank you for allowing me the time to testify on Senate File 3241. My name is Julie Seams, and I represent the Minnesota Conservation Officers Association, and I'm also here on behalf of the BCA Agents Association, Commerce Fraud Agents Association, and Alcohol and Gambling Enforcement Agents Association. We are all members of the Minnesota Law Enforcement Association. As you are all aware, the legislature worked diligently to address a wage disparity issue for all state-employed peace officers, including conservation officers, in the 2021 special session. These efforts were not only greatly appreciated, they were greatly needed. During that process, both legislators and testifiers brought to light the broken process of pattern bargaining that MMB utilizes to address wage negotiations with the MLEA. It was our hope that after doing so, MMB would change course with how they address wage negotiations with the MLEA group in our next contract, but that is not the case. MMB continues to deny the well-documented and readily apparent issues facing the law enforcement profession here in the state of Minnesota and nationwide. One only need to look at the amount of bills brought this session by legislators on both sides of the aisle to see the issue is at our feet. MMB's head-in-the-sand approach places state law enforcement agencies at a disadvantage in the hiring process and will undoubtedly cost these agencies the opportunity to hire the most qualified candidates out of an increasingly shallowing hiring pool. It is imperative that MMB addresses the ongoing law enforcement hiring market that is changing almost daily in our state. We are seeing fewer and fewer college graduates come to the profession, and hiring has devolved into what appears to be agencies recruiting the most qualified candidates from other agencies. In doing so, the market has become extremely competitive, with significant wage increases and costly promotional benefits being offered by city and county agencies to remain competitive in both recruiting and retention. MMB's outdated process and ignorance to the current market situation will undoubtedly have devastating effects in the long run for state law enforcement agencies. We can't wait until the numbers tell us there is a problem. By then, we have already lost our backup to other agencies. This legislation will at least address the act of pattern bargaining with the MLEA group and provide for the use of current market conditions to address MMB's need to provide a competitive wage offer as required under Chapter 43A.18. In addition to this issue, MMB's negotiation process as a whole has caused significant angst and frustration throughout the MLEA group. If one looks at the definition of negotiation as the act of discussion aimed at reaching an agreement, I can say, from many years of experience, that is far from what happens in that room. Rare is it that when presented with an economic offer from the MLEA side, we hear anything other than no, hard no, or not interested from MMB staff tasked with negotiations. On top of that, the dysfunction and disarray of MMB staff in the last couple of contracts has caused inconsiderate use of our time and incessant delays that continually drag our contract out of date by months, if not years. It is important that MMB staff understand that members of the MLEA responsible for negotiations have other important duties to attend to on a daily basis, and that is the protection of the citizens and resources of this state. I ask that you support this legislation and help address this ever-growing issue. Thank you for your time.
Thank you, Ms. Seams. Well said. Appreciate your information. I'm going to ask the page to bring up another chair so that we can have everybody together, so when we ask questions, you'll be more available. I'm going to have the next testifier, Mr. Bennett.
Sure, thank you, Madam Chair. Can you hear me?
Okay, we don't need a chair for you then. Let me ask a quick question. I'm going to go right to you, Mr. Bennett. Ms. Batson, are you here today or online?
I'm joining you online today, Chair.
Okay, you can take the chair back then. We're going to be, I was just assuming. And so thank you very much. Appreciate that, but I think we're okay for right now. Okay, next we're going to go to Mr. Bennett, and he is online. So Mr. Bennett, when you're ready, your name and title, and then go ahead and give your testimony.
Thank you, Madam Chair. William Bennett, B-E-N-N-E-T-T. I'm here today. Good morning. I'm a member of the BCA Agents Association and have been for 10 plus years. I'm currently a special agent with the Minnesota Bureau of Criminal Apprehension. I've been in that capacity for almost 16 years. And actually, next month marks my 30th year in law enforcement. I'm currently assigned in our Bemidji regional office, and yes, it was 21 below and 30-some wind chill, so I appreciate Zoom today.
Well, I have to tell you this, I got married and it was 40 below without the wind chill here in Minnesota. So it's all relative after that, but that's
Sure.
cold, no matter
Yes.
what, that's cold.
So technology is on our side today, for me anyway. Anyway, I'd like to start by thanking everybody again for your support of the MLA last legislative session. It was a big boost for us. I'm here to testify in support of Senate File 3241. The bill would obviously require MMB to not use pattern bargaining for negotiating contracts with MLEA. I personally have been involved in probably 6+ rounds of wage negotiations with the state, and they continually tend to pattern settle. The MLEA group have asked different times to have the MMB negotiating team to let us go first, so we don't have the pattern all the time. So, and that has been met with no luck on our part. MMB has continually used pattern bargaining with our group to settle our labor contracts. Last year's wage adjustment from the legislature for the MLA was greatly appreciated. But since that time, our county and cities have again got their, patterns or got their adjustments and putting us 7 to 9% behind again. We're at critical staffing points at the BCA. When you continue to hear law enforcement across the state with low staffing, historic low levels, and finding good participants or applicants as well. And then on average, it takes the BCA to approximately 199 days to hire an agent. I know personally we've had positions unfilled for years due to staffing needs elsewhere and just qualified candidates. With less qualified candidates, obviously makes the BCA harder to hire. We actually look for seasoned, qualified, diverse candidates to come over to us. It's harder and harder to find that, being that the wage disparity is so lacking. To attract qualified candidates, we need comprehensive wages to get those people that come over to us. We have lowered our standards, and we continue to do so with our experience and education. And we feel that this bill moving forward would help us get maybe a better advantage to hire more qualified candidates to come over to the BCA. This bill will assist law enforcement agencies with recruitment and retention to get the most qualified, diverse candidates to help work with the BCA. I thank you guys for all your support. If you have any questions, I'd sure answer any if there was any.
Thank you very much, Mr. Mattson. I appreciate your testimony. Okay. Thank you very much for your testimony. I appreciate it. With that, we're going to go ahead next to Ms. Batson and members of the committee. After that, I'll go to questions from committee members. So please let Mr. Bjorn know when you're ready or if you have questions. Okay, with that, Ms. Batson, would you go ahead?
Yes, thank you, Chair Kiffmeyer. My name is Kristen Batson. I'm Deputy Commissioner at MMB. MMB is here today to register our concern with a small section of SF 3421, specifically lines 1.16 and 1.17, regarding what is or is not permissible to address when
Ms.
negotiating
Batson,
wages.
before you continue,
Yes?
I'm sorry to interrupt, but I just wanted to be sure you're testifying to the correct bill. I think you said 3421. The bill number is 3241. I just want to be sure we're both on the same page here.
Yes, thank you, Chair Kiffmeyer.
Okay. All right.
So we're here to register our concern with lines 1.16 and 1.17 regarding what is or is not permissible to address when negotiating wages with law enforcement. The bill before you, if passed, would amend the state's compensation statute, 43A.17, for just one specific group of employees, law enforcement employees, so that MMB would be acting in bad faith in the collective bargaining negotiation process by using pattern bargaining. I want to be clear that our concerns here are not related to troopers or law enforcement employees and the law enforcement bargaining unit. Like other state employees, they've been called upon for extraordinary service, and we appreciate the need to recognize their special service. We do, however, have concerns on how that recognition is put into law. One of our primary concerns is that defining bad faith in this way can weaken our bargaining position, not only for this group of employees, but with the other 31,000 state employees and their labor unions that we negotiate with. opening the door to a broad definition of bad faith to include processes and discussions that are widely used and necessary to maintain equitable compensation relationships will create lasting damage. In addition, across the board, wage increases are not the best way to define appropriate compensation levels for a particular group of employees, such as MLEA. MMB does not address market concerns or considerations through the general wage increase process, but rather through a compensation mechanism called range reassignment that is used. In recent years, data has supported market adjustments through range reassignment process for certain nurse classifications, corrections officers, skilled trade positions with the state, and MMB has also addressed range reassignments by ensuring that the wage grids within them are competitive for engineers, nurses, correction officers, IT professionals, skilled trade professionals, and direct healthcare classifications. At the moment, we are still negotiating with MLEA, and these range reassignments and other compensation tools have been part of that discussion with the union as we move towards what we hope will be a voluntary settlement. Another concern with this bill is that the language contradicts some fundamental merit system principles of equal employment opportunity and non-discrimination. MMB has an obligation to ensure internal equity and pay equity, and as such, we oppose statutory language change that would excuse a specific group of employees from the pay equity requirements that the state and all other employers are required to comply with. Our contracts and pay are complex, and some seemingly simple actions have unintended consequences that have long-term ripple effects. They could impact employee morale for other related job classifications. They could result in additional requests for legislative action for other employee groups. They could result in some bargaining units refusing to settle, and all of these could be the results of such an action. In closing, we want to reiterate that 2 lines in this bill, 1.16 and 1.17, would forever codify special treatment for a certain subset of our employees in contravention of the foundational principles that undergird our compensation and bargaining systems. These 2 lines are enormously consequential and are contrary to fundamental principles of pay equity. For that reason, MMB objects and respectfully requests that lines 1.16 and 1.17 be struck from this bill. Thank you, Chair, members of the committee. I can now stand for questions.
Thank you very much, Ms. Batson. I suspect there are going to be some questions in response to you. And Senator Howe, would you like to start?
Thank you, Madam Chair. And I think that it's very important to understand that this bill actually just lasts and it sunsets January 1, 2032. So it resets back to the way it was, but we believe that it's going to take this long to bring our state law enforcement pay and benefits up to a level where they can actually compete. Because when they're that far down the list, we can't afford to bring them all up at one step. So it's going to take a number of years to do that, and we believe that due with the OLA salary survey being conducted in that time, those timeframes, that MMB should be using those salary studies, because I was told by the commissioner that if those studies existed, they would use those in lieu of pattern settlement. But that's not what they have been doing in the current negotiations, even though those salary studies are available for them to use. So even in light that the salary surveys are there, they're active, they're current, they still refuse to use them, and they use pattern settlement. If that would have changed, I would not have brought this legislation here again this year.
Thank you, Senator Howe. Senator Howe, I want to refer you, because it's mentioned here, and I know that we worked on this whole issue for the last couple of years. Current law actually right now requires the legislative auditor to conduct this compensation and benefits survey. It's current law, goes on, and the Office of the Legislative Auditor has done so as required by law. but I wanted to call your attention to, it's the legislature's intent to use the information in this study to compare salaries between the identified police departments and the state patrol and to make appropriate increases to patrol trooper salaries. Could you explain a little bit more about why you worked to get that legislation signed into law?
Yes,
Senator
Madam
Howe.
Chair. We struggled, actually, the MMB had, we actually passed a law to get MMB, or actually, we didn't pass the law. I think it was in negotiations that they were going to do a salary study. MMB did their own salary study. After it was delayed for so long, I decided that we should go forward and actually ask the OLA and pass legislation to have the OLA to do that, because they are independent, and we knew that we would get a true picture without any influence from who was paying the bill. And that's why I think they did an excellent, fair salary study, and that's why we went in that direction, because MMB was dragging their feet on getting the salary study conducted. The other, if you look at that, what we had there in research, under the Public Employees Relations Act in Chapter 179A, public employers are required to negotiate in good faith with exclusive representatives of employees. Refusing to do so is an unfair labor practice, subject to a process before the Public Employees Relation Board that may result in an order to stop the practice and may provide other relief. This order is enforceable by the courts. The last thing we want to do is drag our state law enforcement folks into court or drag MMB into court because of unfair labor practices. I know that they have concerns about those two lines in the bill, but this bill is only good for until 2032. Hopefully, they can negotiate using the salary survey instead of pattern settlement, and we won't have those two lines will have no effect on the negotiations.
Thank you, Senator Howe. One of the things that Ms. Batson seems to object to, though, is to make them a special subgroup of people. It seems to be that their objection it was kind of an odd conversation that I heard there. Senator Howe, I'd like you to think about that and address that a little bit more, but right now I'm going to go to a question, Senator Pratt.
Thank you, Madam Chair, and let me just say thank you to Mr. Ledoux, Ms. Seams, and Mr. Bennett for your service and the service of your colleagues. We appreciate it. I'm not sure who can answer this question, but we have this law enforcement labor services comparison. Better put it on camera. And I'm just wondering, I'm trying to understand how to read this chart, because is this an absolute dollar between so if I were to look at one of my districts in 2022, Shakopee, there's a differential of 56.54 on the minimum and 79.68 on the maximum. Is that on the gross salary? Is that on a per capita basis? How do I read that chart?
Mr.
Madam
Ledoux?
Chair, Senator, the 79.68 is the monthly salary rate. Obviously, if you times that times 12, you would get the yearly top salary for that particular department. I highlighted the Minnesota State Patrol just so it was easy to reference. If we were to accept the pattern settlement of 2.5%, starting in 2021 at top wage, we would be 7% behind the average of that group, which you'll find at the bottom of the 2021 grid and highlighted in blue. Law enforcement labor services, for those that don't know, is one of the largest law enforcement labor groups in the state of Minnesota. I want to say they have approximately 6,000 law enforcement agencies. Law enforcement labor services also, is my understanding, helped the OLA compile the original data provided in the 2021 wage study.
Thank you, Mr. Ledoux. Senator Pratt?
Thank you, Madam Chair. And my next question is for Ms. Batson. Ms. Batson, it seems to me that our state law enforcement officers are unique to other state employees. They have special skills, they have unique responsibilities. Why are you, I'm trying to understand, why are you so concerned with recognizing those differences and breaking this out compared to more administrative employees? It seems to be reasonable to me.
Ms. Batson.
Thank you, Chair. Senator Pratt. The complex answer is that MMB is charged with holding together a system of human resources and labor relations that applies to all employees and with several labor unions. And our concern here in bargaining is that if we stray from pattern bargaining with one group of employees and one labor union, then the rest of the unions will want to hold out to settle their contracts as well. And we will get behind in settling contracts because we have broken pattern for one group, and the other groups will of course want the same.
Thank you, Ms. Batson. Senator Pratt.
Thank you, Madam Chair. Just a comment to that is I think it doesn't really address the unique skills and responsibilities that we're addressing with these. And to that answer, I want to thank Senator Howe for putting the legislature fully in line for this, so MMB can continue to what they do with the administrative employees, and we'll go ahead and take the hit for making sure our law enforcement officers are compensated fairly compared to their peers.
Thank you, Senator Pratt. I'm always kind of amazed at the whole sense that comparing them to others when they put their life on the line is a very special place and service to our people of Minnesota. Senator Howe.
Madam Chair, I think we already selected this group of individuals and these employees to be special and different because we don't allow them, they're considered essential, we don't allow them to strike. Everyone else that they're bargaining with has the ability to strike if they don't like their contract. These individuals have to continue to show up for work. So we've already identified that these folks are different than the other bargaining units that we are dealing with.
Thank you, Senator Howe. Point well made. With that, I'm going to go to Senator Carlson.
Yes, thank you, Madam Chair. And I have just a couple of questions here. First, a statement that it always seems that we get into these kinds of discussion and, deleting the idea of public employees versus private employees, that public employees are always making less, it seems. And we have been talking about this particular group of employees for, I think it's been several years, because I know that we have had a lot of conversations, and a lot of them with Mr. Ledoux in the past also. Now back to the specific bill here. Ms. Batson, you mentioned that you want to see the line 1.16 and 1.17 deleted, but there are two sentences there. Are you limiting your objection to the last sentence, or also the one that describes the salary survey pursuant to section 299D.03? And I guess connected to that, if we would delete that last sentence, would that bring MMB in support of the bill?
Ms. Batson.
Chair, Senator Carlson, our only objection is to the sentence that deals with good faith or bad faith bargaining. Further, we are in the practice, as I indicated in my testimony, of using comparable market data, and we value the two studies concerning law enforcement salaries that have been done and are using them. And we are using them in current negotiations with MLEA, and we really hope to put all of the tools on the table and have a successful voluntary settlement with MLEA in this round of bargaining.
Thank you, Ms. Batson. Senator Carlson.
Yes, thank you, Madam Chair, Ms. Batson. Now, one thing that I see here, we have over 30 police departments that we use as a testimony to the fairness, unfairness of the monthly salaries. Now, do we have other anticipated groups that might not have, say, 30 places to gather comparative data? I think what we need to do is we need to support our law enforcement, and of course, the state patrol has been the premier law enforcement in the state, and it's very difficult to understand using the premier law enforcement organization in the state not as a model for how we pay other people in the state, or vice versa. So what I'm thinking here is that, do we not have a bigger challenge in other types of positions in the state? Now, I'll tell you that long time ago, we talked about this problem with actually even in counties, and having the county salaries be a percentage of the governor's salary. We had other salaries that were limited by the governor's salaries, and we find that that doesn't work. And we're still trying to eliminate those, let's say, those limitations. And I know that years ago, when we lost and this would be under the Valenti administration, when we lost a commissioner of transportation, that there was quite a problem with reestablishing the commissioner's salary and finding somebody who would take it. And so we have had that problem several times in several areas of not being able to use the, and I'll use the term prevailing wage for that particular job as an incentive to refill it. And I think we're having the same problem here with state patrol. And I really think that if we can get your agreement on this, and I think defining bad faith negotiation in the bill might be going a little bit over the top. And so, Madam Chair, I would like to offer an oral amendment to delete that last sentence starting on 1.16 and going on to 1.17 that classifies an action there as bad faith negotiations.
Well, Senator Carlson, considering that this is a hybrid committee, we have to have amendments in writing, and we're required to post them as well. So we want to make sure that is clearly understood. And with that, we're just going to recess for a moment to allow staff and you to work together to get that drafted.
Thank you, Madam Chair. Great, that's great.
We're in recess. Senator Howe, we're going to go ahead while Senator Carlson is working on that. And I think our best use of our time right now is to go ahead and do Senator Duckworth's bill. And so, Senator Duckworth, if you're ready, you're on deck. And members, if you would just stay close. We're going to come back to this topic. I still have questions. And let's take Senator Duckworth.
Madam Chair,
Senator Cran.
No.
Senator Osmic, sorry.
just to mechanically make sure we're following protocol, I move that we lay Senate File 3241 on the table.
On that motion, all those in favor say aye.
Aye.
Opposed? Motion prevails. Senate File 3241 is laid on the table. Okay, thank you very much, Senator Osmick. I appreciate your recognizing that. With that, we're going to go ahead and have, I'll move Senate File 2950, Senator Duckworth's bill. And Senator Duckworth, when you're ready, protocol, of course, name, title, and so on, and then go ahead and present your testimony. And do you know if Mr. May, is he online or?
He should be, Madam Chair.
Be
I
on
see someone
online?
nodding. So.
Okay, all right, good. All right, then you can go ahead.
Thank you. Well, thank you, Madam Chair, for the opportunity to be here, and members of the committee. Senator Zach Duckworth from District 58, here to speak on Senate File 2950, which has to do with the use of the Breeders' Fund. This bill adds a new allowed use of the money in the Breeders' Fund, a fund that supports breeders of racehorses. The new use is to support racehorse adoption, retirement, and repurposing. Money in the Breeders' Fund comes from several fees, taxes, and set-asides on activities related to racetracks and their card clubs, etc. And the modification to current language is very slight. It simply adds that these funds can be used to support racehorse adoption, retirement, and repurposing. With that, Madam Chair, I will defer to my testifier, who has some additional information that he can provide the committee.
Thank you very much, Senator Duckworth. With that, we'll go to Mr. May. Welcome to the committee again. Appreciate you being here in the past as well. If you just go ahead, your name, title, audio record, and then proceed with your testimony. Mr. May, you're not coming through. Still not coming through, Mr. May. Anybody? Staff, anybody here?
Let me try
able?
different. Is this
Oh.
microphone working then?
Okay, now you're coming through, Mr. May.
Okay, I apologize for that. Madam Chair, my name is Steve, S-T-E-V-E, May, M-A-Y. I'm the Executive Director of the Minnesota Racing Commission. Madam Chair, members of the committee, on behalf of the Racing Commission, the horse racing industry, I sincerely appreciate your time and attention to Senate File 2950. And as Mr. Bennett said earlier, I'm appreciative of the virtual participation. Really, that's just because I'm from Texas and went to grad school in Arizona, so I'm still not used to these Minnesota winters. So I appreciate your time and let me testify today. I'm also very appreciative of the work that Senator Duckworth has done on this legislation and for the time that several of the committee members, including the chair, have given us to provide some information and background on this bill. The Minnesota horse racing industry is really a nationwide leader when it comes to programs that give our equine athletes an opportunity to lead full and productive lives after their racing careers are over. The Minnesota racetracks, the horse people that own and train and care for these horses, and the breeding industry all do a tremendous job of providing funding for racehorse aftercare programs. In addition, all of the fines that are levied on racing participants by the Minnesota Racing Commission and racing officials go to various grant programs that help fund these aftercare programs that's pursuant to Minnesota statute. But there's always additional funding that is needed, and the racing industry is always dedicated to finding new revenue sources for these programs. In 2016, the legislature legalized advanced deposit wagering, which allows patrons to place wagers on horse races over their phones or computers and do those remotely. A small portion of the gross wagering from these account wagering operations was dedicated to regulate racing operations in Minnesota and help fund that, as well as to administer the Breeders' Fund in Minnesota. The Breeders' Fund is a program that incentivizes people to breed their horses in Minnesota due to the agribusiness economic impact that it comes from keeping those horses in Minnesota. It was really difficult to estimate the true impact of this online wagering operations in Minnesota when this was legalized in 2016. So there were some statutory limitations that were put on this Breeders' Fund administrative fee that were collected. Due to those limitations, plus the huge uptick in online wagering that resulted from COVID-19, this special revenue fund has grown and it has a balance of just over $480,000 as of February 1st of 2022. The legislation before you today would allow the Racing Commission to expand the use of these funds by allowing the commission to not only administer the fund and promote horse breeding, which is in the current law, but to also use these for racehorse adoption and repurposing programs. The commission currently has a program that awards grants to these operations that are dedicated to the retirement and adoption and repurposing of racehorses after their careers are over. These are important because they give horses a location to call home or even receive training for new careers when their racing days are over. And it's really an important alternative to solutions like horse slaughter that previously were in existence. These funds go directly to the programs for the care of the horses in there, because these are operated all on a completely volunteer basis. The commission awards these funds and they go to feed the horses, veterinary care, all of those actual needs, as well as the upkeep of these facilities. They're all operated as not-for-profit organizations. So the legislation before you today also maintains the current goal of the enabling legislation. It's really a way to promote horse breeding in the state. It's important to breeders to know that when they purchase horses in Minnesota, that there are options for long-term care of their horses that they've been purchased. And so allowing the direct use of these funds for these aftercare programs does provide a positive benefit to the industry. It's also a matter of increasing this funding without the use of anything from the general fund, or it's not an increase on the regulatory fees or taxes on the industry right now. These are existing funds that are just accumulating. So this is a good use of these funds to benefit the horse racing industry and the breeding industry in Minnesota. The Racing Commission is fully in support of this legislation. On behalf of the commission, I would ask that the committee advance this legislation. Be happy to address any questions that anybody might have. So I'll turn it back over to you. Thank you.
Thank you very much, Mr. May. One question I have for you is in regards to the selection of the adoptions, retirements, repurposing, a variety of things. What's the process by which you choose them? How do you select them, and what's the process? Do you have a competitive situation? Do you have an interview? Could you explain that briefly, please?
Yes, and thank you for the question, Madam Chair. So most of these funds really that are collected for these racehorse aftercare programs are actually awarded directly from the racetracks and horse people organizations. So the commission doesn't have a stake in that side of it. What we do have is the fine money that we collect, and that varies from year to year. So once that is determined how much fine money we have, proposals are sent to the commission, and those are reviewed. Those are reviewed first by our racehorse aftercare committee, which has some huge supporters of these programs, and then that goes to the full commission for a final approval of the awarding of those funds.
All right, thank you, Mr. May. That was my concern. Senator Pratt.
Thank you, Madam Chair. Mr. May, can you just, you and I talked about this bill last week, but can you just touch on the fact of the other stakeholders and whether they support or don't support this change?
Mr. May.
Thank you, Senator Pratt. At this point, I've not heard anybody that opposes this. Everyone has been fully in support of this. This was actually, this language in this legislation was actually generated with stakeholder meetings, so they've all been a part of this, and everyone is very much in support of this.
Thank you, Senator Pratt. Thank you, Mr. May. Senator Duckworth, that I don't have any others putting their hands up for questions right now or other things. So if you'd like to make some closing comments before Senator Pratt moves the bill.
Thank you, Madam Chair. None, just thank you for your time and consideration. I greatly appreciate it.
Thank you very much, Senator Duckworth. Senator Pratt.
Senator Osmick, you are the leader of puns. Madam Chair, I move that Senate File 2950 pass committee, and where's it being referred?
Be recommended to pass and be referred to general orders.
Thank you.
On that
Be
motion,
recommended.
Senator Pratt, thank you very much. All those in favor of that motion, please signify by saying aye.
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 Opposed? Motion prevails. Is adopted. Senator Pratt, Senator Duckworth, you're on your way to general orders. Thank you.
Thank you, Madam Chair.
Okay, with that, I'll entertain is Senator Carlson's amendment ready? Has it been posted? We haven't heard anything yet so far.
Madam Chair,
I'm not sure
Steph-
who's,
It's Stephanie.
oh, Ms. James, yes.
Madam Chair and members, the amendment is not quite ready, but will be shortly.
All right, thank you, Ms. James. With that, I'm reluctant to go on to a whole new topic. I think it might be possible to maybe continue asking questions. Why don't you come on up, Senator Howe? I suspect it's going to be ready shortly, so let's go ahead and take Senate File 3241 off the table on that motion. All those in favor say aye.
Aye.
Opposed? Motion prevails. Senate File 3241 is brought up off the table. Senator Howe, we're back to your bill. And members, if you have other questions as well for me, but Senator Howe, I think we'll lead off with you and your anticipating Senator Carlson's question in regards to that sentence. We don't have a motion or amendment in front of us yet, but if you would like to comment.
Well, Madam Chair, thank you. I will just, as far as that line that the MMB objects to, I think the reason that they object to taking out the lack of using that, if you use that internal equity data, the reason they don't want to do that and the reason they don't want that to constitute bad faith in negotiations is because that's the only teeth in the bill. If we take that out, the bill is another piece of paper that's going to collect dust. It does not, it just basically puts no teeth in the bill. There's nothing we can use to actually force MMB to actually use the salary studies. Although it says they need to use it, if they don't use it, where's the teeth? Where's the penalty for not using it? I believe that MMB has shown in past behavior that if there's no teeth there in the bill and the requirement, they will continue to ignore it.
Thank you, Senator Howe. I have a question for you, Ms. Batson. And that question is, you mentioned the OLA report, but you also mentioned that you're using comparable market data. Could you explain what that is, what the source of it is? Ms. Batson.
Chair Kiffmeyer, yes. At around the same time as the OLA comparable report was required, I believe that there was also legislation that required MMB to work with the involved agencies and hire an outside consultant to do a market study report of law enforcement salaries, which we did. That report was delivered to us about a year ago. It was done by a consulting firm called Siegel. And very similar to the OLA report, not a ton of differences, but we do use both reports.
Thank you, Ms. Batson. We have a testifier who'd like to respond to that. Mr. Ledoux?
Madam Chair, committee members, that was not a legislative item. That particular study was agreed upon in collective bargaining. She is correct. The study was done by Siegel. However, if you were to compare the differences in the two studies, I think you would find there was drastic differences. If you look at the OLA study, depending how you do the math, it was either 16.3 or 19.5% troopers were behind the comparison group established by the legislature. The Siegel study, we were limited to about 22 cities. We had very little input into which cities were selected. For example, and I mean no disrespect to the city of Bemidji, but I don't think Bemidji is a good comparison group for Minnesota State Troopers when half my men and women and probably half the state law enforcement officers are metro-based. At the back of our labor agreement, we have language that says the Stanton group is historically the group that we look at, similar to the University of Minnesota. The University of Minnesota police officers have it right in their labor agreement that they will look at the Stanton group, which is metro suburban police departments in communities of 25,000 or larger, which is what kind of provided some of the basis for how we established that group we were going to look at as an apples for apples comparison, so we could pay state law enforcement officers in line with the duties and responsibilities of the position.
Thank you, Mr. Ledoux. I would like you to repeat again. Ms. Batson is saying that this was a statute or law, or I don't want to put words in her mouth, but something to that effect. I want you to repeat again what you said, the source of that comparable market data, what the source of that was, to your understanding, Mr. Ledoux.
The source of that was a study that was agreed upon with Minnesota management and budget during the contractual process. And the problem is it took over a year for that study to get off the ground, and that's why the legislature took
Okay, so Mr. Ledoux, was not a law that was passed or anything like that, correct?
No, Madam Chair.
Okay, thank you, Mr. Ledoux. Ms. Batson, I have another question for you, and that is, considering what we've heard here today, the fact that law enforcement has already been separated out, that they cannot strike like other state employees can. So would you explain again why you think that due to that reasoning, you would not consider that a valid reason to step away from pattern bargaining? Ms. Batson.
Yes, Chair Kiffmeyer. Unfortunately, law enforcement is not the only group of state employees who cannot strike. There's a broader group of employees that includes law enforcement, public safety radio communications officers, healthcare professionals, correctional guards, and professional engineers. So, you know, when we say we support state employees because they really make Minnesota run, yes, and there are a very broad group of them that are essential to making Minnesota run and cannot strike.
Thank you, Ms. Batson. I just think of dialing 911, and I want someone to be there. And I think that is true of all Minnesotans. Nonetheless, I'm going to go ahead next to Senator Fateh. Senator Fateh, please go ahead.
Thank you, Madam Chair. You actually took my question, so, and Ms. Batson responded, so thank you.
Madam Chair.
Yes, Senator Fateh.
Madam Chair, Senator Coran.
I'm sorry, I'm listening to 3 different voices here, so.
Just for the purpose of the bill, I'd like to request a roll call.
Okay, roll call being requested, roll call granted. Senator Fateh.
Yes, my answer has been, my question has been answered. Thank you, Madam Chair.
All right, thank you very much. I see Senator Carlson.
Madam Chair, just clarification, my request was for the bill itself, not any amendments.
All right. So it sounds like maybe we have a roll call requested possibly for both?
Madam Chair, just for the bill itself, not the amendment.
Okay. All right, thank you very much. With that, Senator Carlson, sometimes you don't put your hand down. I'm not sure if it's still up or if you have a different question or if your amendment is ready. Senator Carlson.
This is new. I just wanted to mention that when you call 911, it's the radio operators, the people that can't strike, they're the ones that answer that 911. So they're between you and the responding officers. So we need to make sure that we keep the emergency responses are across the board, and they are more than just the officers. Thank you.
Well, Senator Carlson, I'll rephrase it then. When the 911 operators get the call, they want to have somebody to call to go and answer the cry for help. Thank you very much, Senator Carlson. Senator Carlson, is your amendment ready?
I will have to ask Ms. James.
Ms. James, okay.
Madam Chair and members, the amendment exists and I can email it. I think the paper copies are probably not in the room yet though, but I guess I don't know for sure.
I think at this time, if you just email it and then we'll get it posted and all that. So I'm going to allow you, Senator Carlson, to make your motion, do you have an amendment number so we can follow with it? Or Ms. James, do we have an amendment number for Senator Carlson?
Madam Chair and members, it is the A2.
A2? Okay, Senator Carlson, it's the A2 amendment, if you wish to make your motion.
Yes, Madam Chair. I would like to move the A2 amendment, which deletes the last sentence that begins on line 116 and ends on 117. Thank you.
Okay, on that motion, we've already had some discussion, but Senator Howe, why don't you go ahead? It's important for us to have the chief author of the bill
Thank you, Madam
speak
Chair.
to the
and-
amendment. Senator Howe.
Thank you, Madam Chair, and I will really reiterate my concerns about taking that line out because it actually negates the bill as far as having any teeth to ensure that it is used and applied. Otherwise, we have nothing to ensure that MMB will actually negotiate in good faith.
Okay, thank you very much, Senator Howe. And by the way, the email is in the amendment is in everyone's email at this point. And we've also had sufficient time to talk about it. So we're going to proceed to a vote on the A2 amendment. All those in favor of the A2 amendment, please say aye.
Aye.
Oh, but I'm sorry, Madam Chair. No.
I will.
Let's do it again.
All those in favor of the A2 amendment, please say aye.
Aye.
All those opposed, please say nay.
No.
With that, the amendment does not prevail and is not adopted. With that, Senator Howe, we're back to your bill as presented to the committee.
Thank you, Madam Chair, and I appreciate that. I believe that this is very, very important in order to get our state law enforcement officers protected and have them have the ability to actually use those salary surveys and negotiate and get be able to recruit and retain their officers in this current environment. So, like I said before, this will actually sunset in 2032, and it actually will, hopefully by then, we will have MMB maybe in the habit of actually looking at the current market and using that as a basis for negotiations. Thank you, Madam Chair. With that, I renew my motion for Senate File 3241 to be recommended to pass and be referred to general orders.
Okay. We are in the process of voting on the final bill. So members, we're going to go ahead and Senator Clausen, we have a roll call requested, so we're going to call the roll here. Senator Clausen.
Thank you, Madam Chair. I had my hand up prior to going to Senator Howe, and I just want to make a couple comments because I've been involved in this discussion, I think, for almost 2.5 years, and have written 2 letters to MMB on behalf of our State Troopers Association. And I look back on the whole process that MMB, their delay in really the salary comparison study, the compensation study, the delay in negotiating, letting that contract drag for almost 2 years before a settlement was reached. And then when the salary comparison actually was completed, it was very, very noticeable that our state troopers were lagging behind. And so I really support, and also I voted for Senator Howe's amendment last year. So I really support Senator Howe's proposal here in Senate File 3241, and I'd like to see it move ahead. So thank you.
Thank you, Senator Carlson.
Clausen.
Senator Clausen, Senator Carlson. I was looking to call you next, so.
Yes, thank you. We are often mistaken for each other. But, Madam Chair, actually, Senator Clausen really took the same statement I want to make. I support this bill, and I support the intent of it. You know, my concern is that we may be leaving other people out of the same process and the same mandates that we have here. So, and I've supported this for several years. We have signed letters on it, and so it needs to be done, and it needs to be done right. And I think that we have other occupations within the state that are perhaps underfunded as well as the State Patrol. But the State Patrol has my full support to have their salaries be negotiated with full knowledge of the survey and with full knowledge of the way other law enforcement people are paid in the state. So thank you, Mr. Chair, Madam Chair.
Thank you, Senator Carlson. With that, we have a motion. I'll renew Senator Howe's motion that Senate File 3241 be recommended to pass and be referred to general orders. On that motion,
Madam Chair, I requested a roll call.
I just
Okay,
said.
thanks.
On that motion, we'll call the roll. Ms. Wilson?
Senator Kiffmeyer.
Aye.
Senator Howe.
Aye.
Senator Carlson.
Aye.
Senator Clausen.
Aye.
Senator Fateh.
No.
Senator Curran.
Aye.
Senator Pratt.
Aye.
Senator Osmic.
Aye.
All right, the result of the vote, there being 6 yes votes and 1 no vote, the motion has prevailed. Senator Howe, you're on your way to general orders.
Thank you, Madam Chair and members.
And that is Senate File 3241. All right, members, we'll wait a moment here for Senator Howe.
Thank you, Madam Chair, and we will go to your bill, Senate File 651. Senator Kiffmeyer, to your bill.
Thank you very much, Mr. Chair. So I'll move Senate File 651. This is a real straightforward bill. What it requires, Mr. Chair, before we go, I think I'm going to go ahead and do the amendment.
Do the
It's an
A2.
author's amendment, yes, Mr. Chair.
The A2 amendment,
Yes,
and it
Mr.
is an
Chairman.
author's amendment. This is the first time the bill's being heard, so Senator Kiffmeyer moves the A2 amendment. All those in favor of the A2 amendment, please signify by saying aye.
Aye.
Those opposed, nay. Motion carries. The A2 amendment is adopted. Senator Kiffmeyer, to your bill as amended.
Thank you very much, Senator Howe. So as we all know, we have absentee voting in Minnesota, and it's a no-excuse absentee voting. And so this particular bill talks about location and timing. The reason that I'm offering this bill, which language says, is saying that a polling place designated by the county auditor, interpreted often to mean any election official that is establishing polling places, pursuant to this section, must be at a precinct polling place designated pursuant to section 204B.16. That's a requirement that at the end of every year, polling places are established for the next year. When the county auditor administers absentee voting, all polling places must be open for in-person absentee voting for the entire absentee voting period during the same days and hours as the office of the county auditor is open for in-person absentee voting. When a municipal clerk has been designated, then within the municipality, again, the same, open for in-person absentee voting for the entire voting period during the regular business hours for the municipal clerk's office. What's really important here, members, is consistency and to increase voter turnout. What we've seen in the past is moving polling places. And the problem with that is the ability to manipulate voter turnout by moving polling places temporarily into a certain location, moving them again. And that can cause voter confusion as to where they go to vote. The whole point of the chapter of law that we passed a few years ago, 203B.05, was to have all polling places designated in the year prior to the voting process. And that means that voter information as to where they vote, which is really, really important to actually being able to cast your ballot, comes when you have consistency in the polling places. Prior to that establishment, polling places were changed quite frequently. The whole intent of that law was to have consistency to help our voters, and also to have clarity in regards to they're not being manipulated by moving them around, causing voter confusion. Somebody thinks it's here, by the time they get there, it's been moved. There are just issues like that. So for consistency at having not only the election day polling places be established, but that same law be applied to absentee voting polling place locations as well. I think this is a bill that is very much supported by Minnesotans, that they're able to have polling places in a consistent basis to enable them to know with some certainty about where they go to vote. And I think that I would ask for your support for Senate File 651 for that reason. Mr. Chair, this bill is going to be laid over for possible inclusion, but I think it's also very important that we indicate our support, but in presenting the bill, there will be an opportunity for members in the future to be able to reconsider this as well when it comes up in a future bill. Thank you, Mr. Chair.
Thank you, Madam Chair. And just so everyone knows, Ms. Freeman from the Secretary of State's office is actually available for questions in regards to the letter that was included in your packet. But I see I have a question here from Senator Clausen.
Thank you, Mr. Chair. Senator Kiffmeyer, as I read your bill, it indicates that all polling places will be open that have been designated as such for 46 days for absentee ballots. Is that how, am I interpreting that correctly, first of all?
Senator Kiffmeyer.
Thank you, Mr. Chair. That's exactly what it says, is that current law is in regards to voting by absentee ballot in the office of the county auditor and at any other polling place designated by the county auditor during the 46 days before the election. That is current law. What we're saying, though, is that if they designate such a polling place 46 days before the election, that it would be at a precinct polling place already designated by the local unit of government in accordance with 204B.16, or in the municipality, again, in the same manner. So, but that they would be open for the entire absentee voting period during the same days and hours as either the office of the county auditor, which is generally a county, or a municipal clerk.
Senator Clausen.
Thank you, Mr. Chair. We've had this discussion in previous bills about schools being used as polling sites. And now if some of these schools are designated as such for absentee ballots, that means they'd be open for 46 days. And I know talking with some school districts, they can arrange their schedule for a one-day polling site where they might have that as a staff development day. But to open it for 46 days and to have some of those sites be schools once again, we're creating potentially a public safety issue with schools that are passing referendums and using state dollars to provide security in those schools and safety precautions. And now, again, we're opening these schools up for anyone to come in. Or are we going to have an officer standing there, you know, as a security person, or are we hiring security people? I guess I would appreciate your comments on that.
Senator Kiffmeyer.
Thank you, Mr. Chair. Well, Senator Clausen, by the way, Senator Clausen, you had a bill that we had actually scheduled and then you withdrew, which would have removed schools from being polling place locations at all. And but again, I want to go back to the actual language here. First of all, any other polling place designated by the county auditor must be at a precinct polling place designated, chosen. It doesn't say it has to be at a school. There are many polling place locations that county auditor could choose to use, probably highly unlikely unless there is a special room or some other reason that they could use it. But I doubt that you would have somebody, so they have many options, many polling places to choose if they want to set up absentee voting for those 46 days. I don't know that would be an issue, but if you'd like to bring your bill back up again, which would probably be added to this bill, would add some clarification to that, specifically that they cannot do that, although, so I would just leave that as additional information for you. I hope that is helpful to your question.
Senator Osmink, is it to this point?
Yes. So,
Senator Osmink.
thank you, Mr. Chair. So, Senator Clausen also, and maybe I may have not been totally clear to me, but it is very clear that this is a local jurisdiction issue, and that if I was on a city council or on a county board and I was making determinations where those polling places are, I would take that into consideration. And there are perhaps some schools that would make sense that have the capacity to do something like this. But that's something that the local jurisdiction should easily be able to manage and maintain. Just because we say that we're setting in motion these parameters, that doesn't mean that the local jurisdiction might just outright say nothing at a school. And in my particular city, we don't have any of them at schools. They use churches, which is sort of an interesting concept, but they use a senior center, all kinds of places. I think the local jurisdiction can certainly make that determination better than we can in St. Paul. Thank you, Mr. Chair.
Senator Clausen.
Thank you, Mr. Chair. Well, the county boards and city councils were some of those that disagreed with my proposal because they felt that they couldn't find other locations other than schools and didn't want to be having their hands tied in not being able to find adequate polling locations. So they were some of those that objected to the bill. I think Senator Kiffmeyer's comments are good. If I had more time, probably having an amendment to this that would restrict 46 days of polling at those locations. I think that would be good. And if Senator Kiffmeyer would accept such a thing, I would propose that we have it drafted.
Senator Kiffmeyer.
Senator Clausen, would you be a little bit more specific about your possible amendment?
Senator Clausen.
Thank you, Mr. Chair. Yes, it would prohibit public schools being used for a 46-day as a absentee ballot location.
Senator Kiffmeyer.
Eliminate public schools.
Okay, I just wanted to be sure that I understood. So your concept here would be saying that you'd be explicit about not allowing them to choose, even if it may have been designated for a general election, but that for absentee voting, that would not. I would entertain that, but Senator Clausen, we, through this hybrid situation, have really found how important it is to do things in writing, to just be really clear. I'm open to what you're talking about, but since this is being laid over, Let's talk about that, and when the bill or a bill that would include this would come forth, let's keep that in mind and work on something like that. I'm open.
Senator Clausen?
Thank you, Mr. Chair. I would be open to that. Thank you.
Thank you, Senator Clausen. Senator Carlson?
Yes, thank you, Mr. Chair. And Senator Kiffmeyer, Mr. Chair, Senator Kiffmeyer, I'm a little bit confused here. Maybe you can clear it up that what we're talking about is any precinct voting location that is designated as an election day location also has to be open for the 45 days prior to election day, and also has to provide acceptance services for absentee ballots. Am I correct in that?
Senator Kiffmeyer?
Senator Carlson, no, that is not correct. That is not the plain language of the bill. The bill says a polling place designated by the county auditor. This is not all polling places whatsoever. It's very clear, I believe. But whatever one they do designate in accordance with 204B16, that must be open for those 46 days, but it's a choice of the local county auditor municipal to choose off that list, and it's a rather substantial list quite frequently that they can choose from. This does not require all of those polling places to be open for 46 days. There's nothing in this language that would require that.
Senator Clausen?
Carlson?
Senator Carlson, geez, I can't get this right, sorry. Senator Carlson.
Mr. Chair, and Senator Kiffmeyer, so because I'm not sure if I understand which plain language there is in there, because it does say any other polling place designated by the auditor. So does the county auditor? So does and I don't have 204B16 here. Is that are those polling places different than election day polling places for precincts?
Senator Kiffmeyer.
Thank you, Mr. Chair. 204B.16 in regards to the statute that requires the local units of government to establish polling places to use for the next year in a general election, generally understood to be the November election. So they designate them the year in advance. And so off of that list basically is saying any other polling place designated by the county auditor. So it doesn't say all other polling places, doesn't anything like that. It says any other designated by the county auditor, and further down, or designated by municipal clerk. They need to choose off of that list to have a 46-day receiving absentee ballots. They need to have that chosen location off that list and to have it open for 46 days. I just want to remind you, though, in the meantime, we also have many locations already. The county, in many cases, municipal clerks already have absentee voting 46 days open as well. So these would be additional to those, but only as designated by the county auditor or a municipal clerk.
Thank you, Senator Kiffmeyer. And Senator Carlson, if you'd look at the summary done by Ms. Stangl, I think it actually clarifies that pretty well.
Sure, thank you. Is the summary based on the A2 amendment, Mr. Chair and in council?
Ms. Stangl, was this prepared for the A2?
Thank you, Mr. Chair. No, the amendment was to the bill as introduced, but the concept is still the same. The details are just spelled out a little more in the A2.
Thank you, Ms. Stangl. Senator Carlson?
Thank you, Chair. Thank you, Mr. Chair. And I guess, do we have a fiscal note here? Because in this particular case, if we add 45 days to the absentee drop-off places that are not normally which I think that's what you're trying to achieve here, I would think that we would have to have immense additional security for ballots and immense additional staffing of those places. And is that, has that been estimated to be part of this bill?
Senator Kiffmeyer.
Thank you, Mr. Chair and Senator Carlson. When we do fiscal notes, they are for the costs of the state, but I will remind you that, again, this is designated by the county auditor, not required by the state of Minnesota at all. If they don't have any other polling places designated other than the ones already required by law, if they don't have any, there isn't any cost. There's no way the state of Minnesota could preemptively know what any county auditor or municipal clerk might do. So what this bill is really about is that if they make that choice, then they must be open for the entire 46 days and a location selected in accordance with 204B.16.
Thank you, Senator Kiffmeyer. Senator Carlson?
Yes, thank you, Mr. Chair, and thank you, Senator Kiffmeyer. Is there, are there any auditors that have expressed their support of this, and how about the County Auditors Association? Are there any testifiers in favor of this that this will be visited on?
Senator Kiffmeyer?
Thank you, Mr. Carlson. Because this is a optional, that they choose a different polling place, to my understanding, I have not heard any opposition from them.
Senator Carlson?
Yes, thank you. And I guess from that, I would have to say that instead of causing confusion, as this is supposed to eliminate, what we're really doing is we're cutting back on available locations that the auditors might be able to use for voting. So what we're doing essentially is cutting back on balloting locations, which is something that has been going on across the nation here. And I really have to object to this kind of backdoor or cutting back on voting locations.
You got another question or comment after that, Senator Carlson?
No, that's my final comment on.
Thank you. And before we lay your bill over, Senator Kiffmeyer, any final comments?
Yeah, thank you, Mr. Chair. Remembering that we already have an ample number of ways in which a person can cast their absentee ballot. Minnesota is very generous in that regard already. I think the consistency and the value here of additional locations being chosen and having that benefit to Minnesotans is very important consideration. So with that, Mr. Chair, I move that the bill be laid over for possible inclusion. That is Senate file. Let's see here.
Thank you, Senator Kiffmeyer. Senator
651.
Kiffmeyer, to that motion, Senate File 651 is laid over. Members, we've completed our agenda for the day, so this committee is adjourned.